but it's this issue of matter of LK, which you referenced, which says if the asylum office makes a decision and it's denied, at that point you're out of status. But potentially, when it's still pending, that means that it's USCIS delay, which keeps you in status for the sake of filing for adjustment of status. Maybe not for extension or change of status, but it's particularly says like it's for like a 245A adjustment. And so you said you're filing a case based on that right now.
Yes. Yeah, so this one, so my understanding from the underlying attorney of the underlying case from this attorney is that historically the USCIS, if you have an asylum pending case, hasn't gone to the EOIR, that they will accept that is being in a lawful, it's not that you're being in a lawful status, it's that you have a technical reason. I don't have the language in front of me, but it says that technical reason exception for being out of status. Thus, you don't accumulate, past the 6 months that, which is accepted under 245K. So the case law, this is what's interesting about the case law. I think it's the Ninth Circuit decision basically implicitly says if they have not sent this to EOIR, if they have not sent the case, then it is a technical reason because they haven't taken any action. Like the magic wording is taken action.
In immigration court, you would have the right to file 45, right?
Well, it's not. The question is like all this time is pending. So you let's say your I-589 has been pending for 3 years with the asylum with USCIS, which is was the asylum office, and they haven't made a decision. Well, does that time count as a technical reason for being out of status, such that you can submit an I-140 and not get hit with more than 6 months out of status? And the decision doesn't come out and explicitly say that is a technical reason, but it explicitly says if they refer it to EOIR, then it's not a technical reason.
Yeah.
Okay.
And there's a Sixth Circuit decision that I found that references the same case, and it also doesn't explicitly say that, but again, it infers that over and over that it would be a technical reason for being out of status if you had a pending I-589 with USCIS and it had not been referred to the EOIR. So I do think we have a strong case. The language to me is pretty on point. But yeah, that's the one that we have pending right now. It was denied. They denied the I-140 based on unlawful status.
The I-140 or the I-485?
I'm sorry, the I-45. Sorry, right? Yeah, the I-45. Yeah, the I-140 was approved. The I-485 was denied.
It's such a mix because this issue comes up every 6 months on the listservs, and some people get adjustments, no problem. USCIS doesn't say anything. Some field offices deny it. It's kind of like how TPS is governed. If it's admission, some field offices, it's a wholly inconsistent thing. And just today, the Eighth Circuit, I think it was, considered TPS as admission, which is wonderful. Now
really?
The 3 circuits positively said TPS is considered admission by itself. So that's a game changer. But we have mixed results in these different jurisdictions still. Where is the Eighth? I'm not even sure where that is. I gotta love
the Eighth. My map above me has it there.
Oh, there we go.
The Eighth is everything from Arkansas up to North Dakota.
Not bad. That's a good district. Yeah.
Yeah, I mean, it's not. People are afraid of filing lawsuits in the Eighth Circuit. Yeah. I do file some of my lawsuits in Nebraska, and they actually have some precedents that are friendly in immigration.
Interesting. I really want to get this stuff, at the very least, marketing and letting people know these options exist. So we'll definitely work together on this.
David's got more cases than he wants now, right? This started off as just a couple of your cases, and now it's part of your practice, right?
Yeah. I mean, we've got I mean, this morning I was on the phone all morning with U.S. attorneys and following up with these. So yeah, I mean, this is the time.